So today we're going to start the section on racial discrimination in civil rights and liberties, and the method by which we're going to do this is a little bit of a historical review. And there's absolutely nothing in this history that will be new to you, but it's just to set the stage for when we get to the first case in which the United States Supreme Court handles race, Dred Scott v. Sanford, that you'll see sort of the playing field as it's been established um, through the histories. So there's absolutely no issue that has dominated and continues to dominate constitutional law as much as the question of race. Racial discrimination still dominates constitutional law and the ways in which we address constitutional law. This entire section that takes up a third of this class could easily be its own entire semester. And there are numerous questions which I've cut out simply for lack of space that are absolutely important questions. And my focus primarily on African American civil rights is also a conscious choice. I could have chosen to focus on other areas of civil rights, and I didn't, because I chose to very much focus on one area at the expense of others, just for the sake of content and space. But this can go even a little bit further. There's absolutely no issue that's dominated our history, our collective history as a country, as race relations have in the United States. There's very little in terms of how we discuss politics even today that doesn't stem from how individuals of different races were treated at the founding of the nation. It is, in essence, the United States' original sin. Slavery, that is. Slavery is basically the United States' original sin. And because of that, our Constitution and our constitutional evolution deals with it, our history deals with it, and our politics still up till today deal with that that original sin. And so we're going to look at it in a very limited way in the context of this class, understanding that there's a lot more out there that I just don't have time to cover. So the origins of this race-based distinctions in the Constitution absolutely arise because of slavery, and furthermore arise because the Constitution absolutely permitted slavery. The Constitution explicitly mentions the institution of slavery, and furthermore explicitly allows it and even makes rules surrounding it. And this continues through the Civil War amendments, the 13th, 14th, and 15th Amendment. We can see that slavery is very much a continuous thing in terms of constitutional law, and it's something that we still litigate up to this point. The way that we generally think of this is that presidents and Congress, largely starting in the 1930s and even into the 40s, have been pretty supportive in getting rid of legally enforced discrimination, that is, discrimination that is enforced as a means of law. But the Supreme Court was not very supportive in those efforts. And because of the way the Supreme Court interpreted the 14th Amendment, many of these laws that were passed early on, and we'll really get one with the Civil Rights Act of 1889, were struck down as unconstitutional for the irony that they were treating individuals of different races differently. And so the Supreme Court had, for much of its history, was not supportive in this regard. The court attempts, somewhat beginning in the 1890s, like I said, Civil Rights Act of 1889, and through the 1960s, to deal with these issues. And that's really the time span that we're going to be focusing on in this class, is the 1890s to the 1960s, though we will do some cases as recently as, I think, 4 years ago. But we're really going to focus on this period because this is really where the court attempts to address its failings in these issues and address the United States' own as a country failing in these issues, and attempts to provide some remedies for these issues. And the remedies in some cases are exceedingly effective and in other cases are not. And they also range from popular to unpopular. The problem is once the court begins moving, once the court begins working in this area in the 1950s, 60s, and 70s, is that elected officials saw the court's willingness and let them do stuff and try stuff. And the reason for that is the court has life tenure. Those judges are going to be there whether they're unpopular or popular. And so the thought was, at least within Washington, we'll let the Supreme Court try stuff, let them give it a go. And if it's unpopular, well, then members of Congress and the president, they're not going to be punished because of it, because that's the court acting, and the court is independent, and the court goes its own way. And the court, most importantly, doesn't have to worry about re-election. And so once the court begins addressing these issues, what you actually see is Congress and the presidency sort of pull away and pull back. And so it's an interesting a juxtaposition of how active Congress and the presidents were before this time period and how much they sort of retrench in terms of their activeness during this time period. This issue of how to handle race and how to handle laws that make distinctions based on race or laws that attempt to eliminate distinctions based on race. In terms of civil liberties, it's the most important discussion in this country, and part of U.S. history is how governments handle protection of civil liberties while being race conscious. And it's something that the court is still working through, and courts are still working through. But what we're going to do in the context of this class is see how the court evolves on its thinking on racial issues, and also how the court evolves in terms of dealing with laws that attempt to either A, discriminate, or B, resolve discrimination. And the court evolves significantly on both of those dimensions. So the Constitution doesn't directly mention slavery because, it's not that as though slavery was a popular thing even when the Constitution was being drafted. And I mean that in terms of on its face. Slavery was overwhelmingly popular. The enslavement of primarily African Americans was overwhelmingly popular at the founding of our nation, but the concept of slavery was not. The act of it was, but the concept of it, no man wanted to be a slave. So we're not going to put that in the Constitution, but we'll provide nods and whistles towards it all throughout the document. Perhaps the most notorious here is the Three-Fifths Compromise, that very explicitly spells out, for purposes of taxation and representation within the states, that slaves are going to count as 3/5 of a regular individual, of a non-slave. And so this compromise, which is built in, fixated in the functional means of our electoral system and our taxation system. So our taxation and electoral systems have this 3/5 nature built in from the get-go. So it's just there. It's explicit that slavery is the reason for a number of these institutions. And obviously the Three-Fifths Compromise is no longer good law. But the institutions that were built around the Three-Fifths Compromise, like the Electoral College, for example, absolutely still exist. And so for reasons of apportionment and taxation, according to the respective numbers, which shall be determined by adding the whole number of free persons, including Indians non-taxed, and 3/5 of all other persons. So your Three-Fifths Compromise, a very early thing that path dependently sets the country on a circumstance by which almost makes the Civil War inevitable. Uh, the provision itself, the Three-Fifths Compromise, arises almost primarily because of Northern pressure on the South. And the reason is, for obvious reasons, is that Southerners, those who represented the Southern states, wanted individuals who were slaves to count for purposes of population, but not for taxation, which not going to fly. And so the Northerners proposed this compromise and also build it into electoral mechanisms. So there's a reason why the upper branch of government, so the Senate, the upper branch of the legislature, has 2 representatives per state, irregardless of population, is that it made at the time northern states equally as powerful as southern states, whereas in the House of Representatives, southern states were going to dominate because of their slave population. And so that compromise is built into the document, and it's a compromise we're still dealing with today, if only for a simple reason of Rhode Island has exactly as much representation in the Senate as Texas does. Doesn't seem to make logical sense. That's not how representative governments work, but that's how our representative government works. And part of the reason for that is slavery, this Three-Fifths Compromise built into the document. Another compromise that exists within the Constitution required the extradition of slaves to their home state. So extradition is the process by which individuals arrested or captured, and captured is probably the better context in terms of slavery in this regard, but individuals who are in government control must be extradited to their home state, which meant that slaves couldn't simply run away to a free state. The Constitution explicitly required them to be extradited back to their home state. And Congress even goes so far as, once Congress comes into existence, to pass the Fugitive Slave Act of 1793 to enforce this and provide even more institutional support around the extradition of slaves back to their home state and back to their owners. So again, explicitly built into the document. Some examples of other laws that Congress passed very early on. 1787, slavery was prohibited in the Northwest Territory. Northwest Territory, because we had not explored, was simply Ohio, or the Ohio territories like Ohio, Indiana, Michigan. I apologize for the dogs in the background, but people think it's cool to have pets and just let them run around. And those are horrible people, and you should not be like those people. From 1794 to 1807, any number of laws were passed, almost a countless number of laws were passed, which attempted to restrict the slave trade without absolutely abolishing the slave trade, but attempted to restrict it in a variety of ways. But from 1807 on, Congress began passing laws which attempted to stop the slave trade, amongst also simply made it illegal to import slaves from Africa. What this didn't do is stop a black market slave trade, which still existed and still carried on in the South far after 1807. In fact, far after the Civil War, a black market slave trade was still in effect in southern states. But Congress is at least trying to address the issue from 1807 on, sort of setting the stage for what ultimately happens with the Civil War. And like, as I mentioned, illegal slave trade continues to go on. And why did the illegal slave trade continue to go on? Because it was overwhelmingly economically beneficial for the individuals who were working in the slave trade, and for also Southerners who wanted more slaves. What really brings this all to the head, though, however, is the Missouri Compromise Act of 1820. The Missouri Compromise Act of 1820 really puts the North versus the South in a very explicit way. All of the things that moved before this the prohibition of slavery in the Northwest Territory, laws which restrict the slave trade. All of this is sort of beating around um, explicit anger between the North and the South. The Missouri Compromise Act of 1820 pretty much does away with that. Here's what the Missouri Compromise Act of 1820 does. It establishes this line and creates the existence that if a state enters the Union above this line, they're a free state. And if a state enters this union below this line, they're a slave state. But you'll notice there are a number of states above said line which are slave. All of these states were already slave states before this time. The one that should stick out to you, however, is Missouri. Because the compromise allowed Missouri to enter the Union as a slave state if all the other states could enter as non-slaves. So you'll see, look very close to Texas. There's a reason why Texas doesn't start until that parallel, is that so that Texas could enter the Union as a slave state. It's not that Oklahoma had an amazing claim to this little sliver of land. So that Texas wanted to enter as a slave state. So they were willing to cede that acreage of land so that it could enter the Union as a slave state. In 1854, the Kansas-Nebraska Act was passed, and the repealing of the Kansas-Nebraska Act was, in many, many, many ways, the first sort of shot of the Civil War. What the Kansas-Nebraska Act did is it repealed the Missouri Compromise, and it allows new territories entering the nation to decide whether they were free or slave. So, hey, let's stop mandating states whether they enter free or slave. Let's let them decide themselves. Let's have the autonomy of self-determination. This is known collectively as popular sovereignty. Let the states decide. Let the states to determine how they wish to enter the Union. And what this creates is it creates a circumstance where politicians actively have learned that you don't touch slavery anymore. That slavery is, at least in the 1850s, the third rail of politics. You don't mess with it because there are electoral forces at stake. Just like we look at members of Congress now and claim them to be cowards because they won't do something. Well, the reason they won't do something is because there are electoral reasons not to do it. Slavery was very much the electoral reason not to do stuff in the 1950s. President Buchanan, when he takes office, explicitly says that he's not dealing with slavery, and even pushes the ball directly in the United States Supreme Court's lap and says that the issue will be finally dealt with once the Supreme Court has decided. We will speedily and finally have it settled. So members of the elected branches of government weren't touching this thing, and very clearly went, the Supreme Court can figure it out, because they're, for exactly the same reasons why the Supreme Court deals with the civil rights era in the 1950s and 60s. They're independent. They're not elected. They have life tenure. They have all of these qualities that members of Congress and the presidency don't have. Why don't we let the non-elected branch of government be the ones that take the lead in this regard? And they most certainly do take the lead. That lead, however, is not good. And that lead takes us to Dred Scott v. Sanford, which literally 3 years after the Kansas-Nebraska Act, we see the Supreme Court use, for the second time in its history, judicial review over acts of Congress. The first time was Marbury versus Madison. The second time is Dred Scott v. Sanford. And that's where we're going to pick up on Thursday. and sort of start us down the train that will ultimately lead to the 13th, 14th, and 15th Amendments. And for the purposes of this class, what we're going to be focusing on in large part is the 14th Amendment, which largely becomes the workhorse for all of civil rights and liberties moving forward in the United States.